our guest of honor, Sufi Muhammad Mizanur Rahman, Chairman, Board of Trustees, UITS, and PHP family, and recipient of Ekushe Podok Award. What a pleasure and honor it has been, sir, to make your acquaintance. Thank you, sir. This special guest, Professor Dr. Abdullah Al-Farouk, Senate member and former Dean, Faculty of Law, University of Chittagong. Welcome. The session chair, Professor Dr. Muhammad Abu Hashan Bhuiya, Vice Chancellor, UITS. Hello, sir. Esteemed faculty members, students of the Faculty of Law at UITS, ladies and gentlemen, Assalamu alaikum, and a very good afternoon to you all. It is significant that I find myself today in the midst of legal academia at a point in time when I am in between two worlds, so to speak. This transition, marked by growth and expansion, creativity and collaboration, innovation, renewal and rejuvenation, reflects a leap of faith that takes me back to my alma mater, Wadham College, University, Oxford, in a few months. Inshallah. The coming academic year shall see me in residence at Wadham in my dual capacity as honorary and visiting fellow. Wadham College, with its legacy of progressive thought and dissent, has long been associated with those who dared to speak against orthodoxy. Unsurprisingly, therefore, if you ever go to Wadham College, and I hope some of you may in the not so distant future, you will find that there hangs prominently in Wadham's senior common room a portrait of a man almost forgotten by history, a man named John Cook. John Cook was a Wadham alumnus who was the first Solicitor General of the English Commonwealth, but his notoriety and his rise to fame is chiefly attributable to the fact that he initiated the prosecution of King Charles I. Cook had built a reputation as a highly original and a progressive lawyer, if not a radical one, and played a pivotal role in bringing charges of high treason against Charles I. At that time, we're talking about 4 centuries ago, in the 17th century. At that time, the trying of a reigning monarch had no precedent. Previous monarchs had been deposed but none had been brought to trial. It was Charles I who was first charged broadly with the offense of what we now call tyrannicide. And as we all know, he was found guilty and he was executed in 1649. And among those who were in the Civil War, the English Civil War, of course, the more famous name is that of Oliver Cromwell. And now I'm going to be introducing to you the nearly forgotten character of John Cook. And there's a reason why I do that. And I hope it becomes clear in the course of my presentation this afternoon. Moving on beyond the execution of Charles I, of course, history buffs will know the restoration of the monarchy took place several years later. And of course, upon the restoration to the throne of Charles I's son, Charles II, John Cook, who had masterminded the trial against Charles I, he himself was convicted for regicide, for the killing of a monarch, and was brutally executed himself in 1660. But that has not stopped Wadham, my college, and his alma mater from celebrating John Cook's legacy since. Now this begs the question, why is still John Cook remembered? Why is he still relevant? It is therefore not only sheer nostalgia that constrains me to summon up the reference to Wadham College this afternoon. It is something far more profound. I transport you, ladies and gentlemen, back to a tumultuous chapter, not only in English political history, that is the Civil War of 1642 to 1649, but also English legal history, dominated by an unsung hero called John Cook. You see, ladies and gentlemen, the Civil War sought not only the abolition of divinely ordained monarchical absolutism concentrated in the person of King Charles I, but it also sought the creation of an equitable republican order, something that I think you can relate to by reference to the revolution of July and August 2024. Republicanism, as understood by Oliver Cromwell and his revolutionary cohorts, would expand on the 13th century Great Charter known to us all as the Magna Carta, to further solidify the notion of rule of law and equality before the law. While the Magna Carta established a balance of political, economic, and legal power between the monarch and powerful land barons, the English Civil War provided a catalyst to expand on the notions of rule of law and equality before the law, to encompass the rights and protection of the common man. The Civil War, therefore, was truly proletarian in that sense. In the course, for much of the Civil War, Charles I, ironically, sought sanctuary in Oxford. And he held court at one of the more famous Oxford colleges, Christ Church. And at the other end, it was our Oxford man, John Cook, who was rewriting the tenets of justice delivery, due process, and professional conduct, sitting in London. In February 1646, at the height of the Civil War, Cook published his book-length pamphlet, and it's a long title, and the title is The Vindication of the Professors and Profession of the Law. I will hereinafter refer to this book simply as Vindication. So the pamphlet Vindication introduced certain bold and revolutionary ideas on conduct of court cases, which incorporate the core tenets of the notion of rule of law, that is, equal application of and protection under the law, and fair practice at the bar, aided by a meritocratic judiciary. Ideas which are very modern and very relevant and current today, but which in certain cases took centuries to gain a strong foothold, were written about by John Cook 400 years ago. So he was much ahead of his time. He was a visionary. As John Cook himself believed, the Civil War, you can draw parallels. When I refer to the Civil War, you can draw parallels with our own revolution of July and August 2024. That the Civil War was also fought to reform the law. Because as Oliver Cromwell, the more known protagonist of the Civil War, once declared that the law of the time, that the law of the 17th century England, was seen only to maintain the lawyers and to encourage the rich to oppress the poor. The 17th century English Civil War, therefore, ladies and gentlemen, serves as a critical juncture in the transformation of an extractive political order to a more egalitarian legal order, where the end result was the rule of law transforming a thus far passive, disgruntled, and exploited population, English nation, into active participants of an inclusive or pluralistic political order. Rings a bell? Think of the transformative influence of yet another critical phase in this country's history, July, August 2024. That was also a critical juncture in this nation's history in transforming our concept of the rule of law, delivery of justice, and institutional reform. I am tempted here to briefly introduce you to certain of John Cook's innovative ideas. Innovative by 17th century standards, but very relevant and current today. In these ideas as incorporated in vindication, I will just cite a few. Number one, Cook said that any lawyer holds in trust fees for due and professional services. You hold it in trust, which means that at the end of the day, you cannot bring justice to the aggrieved person. You are duty bound, you're obliged to return the fee. Which leads to the second point, that if you as a lawyer from the very outset are not convinced that you can ensure due success to your client's case, then you must not take up that case. You must not put your client through a frivolous claim, costing your client a lot of money and wasting a lot of time of the court.
এবং আপনার বাপে অক্ষরে অক্ষরে পড়তো কেসের মেরিট এন্ড ডিমেরিট।
Thank you. Thank you. Lawyers are also duty bound to advise on the exact limits of the law. The law, any given law, does not promise you heaven and earth and anything under the sky. Every law has its limits of the benefits that can be derived from it, the guarantees it sort of, ensures you. It is a lawyer's duty to apprise the client at the outset what the limitations of the law are, what the limits of the law are. Another point, students of the law, all of us here, the test of the reading of a situation or the evaluation and assessment of a situation by using the reasonable man test. John Cook says that the reason of the law is not necessarily the meaning attached to a law by every natural man, but rather it is that meaning attached to the application or the interpretation or the thrust of the law which comes after considerable practice and intensive study. So when you give a reasonable interpretation of the law to your client, it is not something that, a common man will attach to that law. It is something that you have understood by burning the midnight oil and what you consider to be your considered and best point of view as a lawyer, your client. Cook also insisted that accurate pleadings and prompt prosecution and disposal of cases as the sine qua non of professional integrity, or to avoid professional negligence. He also believed that equity must necessarily step in where the law stops to provide any relief. And something that is hotly debated in courts today, if you bring frivolous claims or you take adjournment after adjournment after adjournment in case, will the court impose costs? Because you're doing disservice to your client and you're doing disservice to the other side. So he believed in imposition of costs and prosecution for perjury if a lawyer or a private citizen insists on the pursuit of trivial and false actions. And last of all, the guarantee of the right to silence, or the guaranteed protection against self-incrimination. This had a greater significance in the sense that in the 17th century, 16th century England, confessions were secured through torture. Courts, if a legal system enshrines the right to silence, that automatically reduces the propensity of the system to encourage or to accommodate resort to torture. And this notion of guarding against self-incrimination, ladies and gentlemen, you very well know, is now enshrined as one of the most fundamental provisions of the pillars of the US Constitution, as we all know, and indeed in our Constitution as well. The beauty of Cook's book, Vindication, for me personally, is also that it delves into the question of my favorite jurisprudential area of research, that is the morality of the law. In other words, it impresses upon us that law, at the end of the day, is a moral idea. It teaches us to cultivate a sense of personal morality, and it also teaches the system within which law operates to operate on the basis of a political morality. Cook also enjoins upon us to appreciate the culture of critical reasoning, both at the bar and the bench. Central to that idea is the study and understanding of legal history. Not only should the bench be adorned by good men and women of high moral character, but by judges who have a proper grasp and understanding of the origins of the law and the evolution of core jurisprudential principles. Fundamentally, nearly 400 years after its publication, John Cook's publication, the book, Vindication of the Professors and Profession of the Law, reads to me personally as a reference point of benchmark for law reform with which I was very deeply involved in the post-July 2024 Bangladesh. My inclination as a jurist of the realist school, I mean, if I can sort of, take a pause here, students of jurisprudence will appreciate this greatly. There are, in very broad general terms, two schools of thought: the positivist school of law and the realist school. Positivists, I see a lot of people nodding, thank you. That's very reassuring for me. It's nice to get the feedback. The positivist school believes that, law the text that you read should be treated from a purist point of view, that the law is how it reads, and you should apply it strictly without possibly taking into account whether at the end of the day it does injustice or it serves justice. So the strict application, the letter of the law. That's the positivist school in broad terms. The realist school, the other end of the spectrum, is quite different. And that I belong to that school. I believe that law, first and foremost, is moral in all its dimensions. Its thrust is to do good, to be beneficial to society at large. And any application of the law, which I as a judge foresee as bringing injustice, I shall try to apply and interpret the law as serves the need of that particular case. I will mold it, I will shape it in such a manner that it yields the best result possible. And in doing so, I will study not only the history of the evolution of that law, I will study societal circumstances, the reality on the ground, against the backdrop of which a case arises, and I'm asked to apply the law in that circumstance. So I'm a realist. So I play with the law. I tinker with the fundamental basis of the law. I have to get the best desired result out of the application of the law. So I'm a realist. And I think my realism comes in many ways from the many hours I spent studying English legal history while I was at university, at Oxford and elsewhere, and also my weakness for understanding political history. So legal history married with political history. All that sort of, the confluence of the two creates a judge or even a lawyer who has a true understanding of the intention behind the making of that law, or the purpose of that law. Yes. I believe too that justice is based on the understanding that law and morality are intertwined concepts, in turn determining how justice is at the end of the day delivered. As a realist, I submit that efficient and effective delivery of justice must involve a determination of the substance, the core substance of the law. You have to dig very, very deep into the constituents of the law to bring out its true essence. It is not an easy task, but it has to be done. There's no other way about it if you want to deliver justice. That indeed has been the thrust of common law principles that have evolved over the centuries in the field of judicial review, what we call the writs, the issuance of the writs, certiorari, prohibition, mandamus, quo warranto, habeas corpus. That is the essence of the right of a citizen under Article 102 to move to the High Court, to seek protection against perceived or actual arbitrary, exercise of power against a common man, common citizen. And what do we do through the exercise of judicial review? This, this inherent constitutional power given to the High Court Division of the Supreme Court. Broadly, two things. That we check, it acts as a check and balance on absolute or arbitrary executive power. So we check and examine the legality of executive or government decisions or of administrative authorities, and far more fundamental, we can also question the constitutionality of laws or even amendments to the Constitution. The content of these principles that we see in our common law pronouncements, enshrined in our Constitution, or even, a very comprehensively drafted piece of legislation, is that our legal system, to a large extent inherited, is a historical inheritance. It's a colonial inheritance. But it has its salutary features as well. And what are these salutary features? That they are derived from the concepts of political and personal morality. Ajke we saw, and I think we will hear Sufi Sahab in the course of the afternoon today, and I was having a brief discussion with him before I came into this auditorium on the standards of morality that's inculcated into the student body here and members of the faculty.
You see the discipline of the children.
Yes, I'm quite remarkable.
They are wonderful.
Quite remarkable. So this is a question of personal morality, which should, in any ideal system, be inculcated and permeate through to other levels: personal, institutional, and political. Personal morality, institutional morality, and constitutional morality, all governed by this broad concept of law as a moral idea. Justice, concepts like justice, liberty, equality, and the ability to distinguish between the right and the wrong. It becomes imperative for the judiciary to rely on these principles on a daily basis as interpretative concepts in finding and identifying the true proposition of the law, the substance of law. Furthermore, and I hope that as responsible citizens of this country and flag bearers of a new Bangladesh post-2024, I hope you also subscribe to this idea that the sum total of these concepts, again, justice, liberty, equality, right and wrong, that these concepts, the sum total of these concepts constitutes the foundation of any truly democratic order. And what ideally should be the dynamics or identifying features of such a substantive democratic order? In my view, again, we should be aiming for limited government. Beneficial governance and the supremacy of the rule of law. That supremacy of the rule of law can manifest itself, in my view again, first and foremost, in the will of the people. As an ordinary citizen of Bangladesh, you and I share a common will. That is normally reflected through our constitution. And any constitution, any ideal constitution, ladies and gentlemen, will aim to broadly curb the authority of arbitrary governance. It will not grant absolute authority to any power or entity in the state to govern without limits. And you hold on to the brakes of absolutism or arbitrariness or authoritarianism through the mechanism of a constitution that firmly entrenches the concept of rule of law. Going back to the Constitution, ladies and gentlemen, you will see that the 1972 Constitution, let me say a word for the 1972 Constitution. It is a good document. It is a resilient document. You know why? It has survived for nearly 54 years. And it has suffered for 54 years, mainly through self-serving, sometimes politically immoral amendments, but it has survived. And it is that resilience that you must acknowledge and commend the Constitution for. The Constitution, as I was saying, if you break it down to a very simple concept, is nothing but a social contract. It is a social contract struck between every member of the audience here as a national and a citizen of Bangladesh with the political powers that be. It's a contractual relationship where we as a nation, where we as the people, the repository of sovereign will, have chosen, have consented to hand over, delegate limited powers of governance to an elected authority. We still retain a huge chunk of our constituent power. Not everything is delegated to an elected government. The bulk of constituent power is retained by the people that can manifest itself at any point in time, either through regular elections or the remaking or the amendment or the rewriting of a constitution, and in extreme cases through an outpouring of public emotion and sentiment, sometimes anger, through an uprising or a revolution, which ushers in a convulsive reordering not only of our socio-economic existence or political order, but our understanding of the adequacy of the existing constitution. Ladies and gentlemen, we are at that point of transition in our political history, even as we speak. The transition is ushered in by July, August 2024 is not over. We have just moved from one phase of the transition to yet another. And we have yet to see where this will take us. We have broad ideas of systemic reform, institutional reform, constitutional reform. But where it will take us, it's the genius of the people that at the end of the day will determine the course of this path of reform and its ultimate destination, and how and when we reach that destination. And that is where your generation of lawyers, students, thinkers, possibly politicians, administrators, will have a huge role to play in the months and definitely in the years and decades ahead. So I am basically, Sufi Saab, we are basically addressing the movers and shakers of tomorrow's Bangladesh. So it's an onerous responsibility that our generation will be passing on to you. You're aware, you're familiar with the works of the British political thinker, educator, and quintessential realist, Harold J. Lasky. He confined the idea of the state within a very narrow and utilitarian framework. Lasky viewed the state merely as a means, nothing more, as a means of regulating human conduct. In his view, the state has a particular legal function, that is to stand as the definitive arbiter for society. That is a body of individuals who, when required, must conform to an established mode of existence and way of life. Similarly, for centuries within the state, law was largely perceived as an adjudicatory institution to resolve disputes and preserve social order. Law was maintained not always out of moral conviction, but often because the rulers of the state understood its utility and instrumental value to balance their tensions with the governed and to sustain stability within the society. So it had a largely regulatory function. As Bertrand Russell observed in his collection, Mortals and Others, and I quote, all the great writers of the Middle Ages were passionate in their admiration of law. Bertrand Russell says, law, if respected and inflexibly enforced, is in the long run the only alternative to violence and anarchy. End quote. Thus, the law was valued because it liberated and it restrained, because it equalized as well as maintained order. But as 21st century citizens of a modern state, and as lawyers to boot, we must, however, remember that a legal system is not a mere embodiment of just rules in a statute book or a law report. It is the expression of a general will, what you and I collectively think. It is the expression of a general will that calibrates the state towards its foundational and rather minimum purpose to ensure the common good. Law is there simply to do good for you and I collectively and for the common man individually. Indeed, if we go back to the 20th century, World War I and of course the Second World War, and that is what I'm referring to here. Because that also was a critical phase in the history of humanity. The excesses, not only of the First World War, but definitely of the Second World War. And bearing that in mind, we must remember that a legal system is not a mere, as I said, embodiment of rules, but it ensures the common good. Indeed, as humanity in the 20th century endured the deepest wounds of injustice and witnessed the catastrophic consequences of unfettered exercise of state powers, a new moral consciousness emerged through the proclamation of the Universal Declaration of Human Rights, which redefined the very purpose of law and in turn, for the first time, imbued the idea of a state with a renewed meaning and construction. Our experiences of the Second World War reminded us that if a man is not to be compelled to have recourse as a last resort to rebellion against tyranny and oppression, then human rights must be protected by the rule of law. Nearly, well, it's about 80 years now since the end of the Second World War. It's a different question now whether we should, as part of a renegotiated global order, we must have now called for a new generation of human rights. Brought on by, questions like involuntary mass migration, climate justice, sharing of natural resources, water. For future wars, ladies and gentlemen, future wars will be fought over things as mundane as water.
Not oil.
Not oil. And this is something that your generation is going to be inheriting. So human rights must be protected by the rule of law. And it is within this universal awakening that our own national history finds its resonance. One of the defining moments of global history, not only our national or regional history, one of the defining moments of global history was 1971, which saw to the emergence of Bangladesh as an independent sovereign state. People, even today, rally behind flags, languages, and identities shaped by heritage. They chant slogans in the name of land, speech, or shared bloodlines. But when people rise to demand a new nation, it is not merely to redraw boundaries or redefine identities. It is for something more profound, and that is something that we have learned from Gen Z in 2024 in Bangladesh. Because that uprising, whatever name you call it, it's a matter of semantics or revolution. The young and the bold in Bangladesh in 2024 rose for justice. Nothing more, nothing less. When a state no longer protects the dignity of its people, when it silences their voice and denies their rightful place in the political, socio-economic order, ladies and gentlemen, the fight for justice becomes a moral necessity. It's no longer a political necessity, it's a moral, it's a human necessity. It's a matter of human existence with dignity. Our legal system, when viewed through philosophical lenses, therefore emerges not as a static machinery, that it's just rooted there and it will not move, it will not evolve, it will not devolve, it will not change its contours. That's not the state system we created in 1971. But we have to treat our state order and our institutions, even tertiary educational institutions taken together, as part of a living organism, forever growing, forever adapting, and forever continuously responding to the moral pulse of the society. If any institution, if the state, any institution, for example, the judiciary, or even a tertiary educational institution as this, if any institution loses grip of that reality, then it stops being relevant. It becomes redundant. It becomes superfluous. And it is with that philosophy in mind that the post-July 2024 Bangladesh embarked on possibly a very, very long journey of institutional transformation. As Aristotle, I saw something on your desk. There was a sort of a write-up on Aristotle. As Aristotle observed in his timeless work, Politics, there are three elements in every constitution which every serious lawgiver must consider. If these are well arranged, the constitution itself is bound to be well arranged. And these three are, first, the deliberative, which discusses everything of common importance, i.e. modern day parliament. Second, the magistracies, which is executive magistracies. By that he meant the executive order. And third, the judicial element, which is modern day judiciary. That ancient wisdom later matured into the relative modern theorization of separation of powers, foregrounding that the legislature shall make the law, the executive shall enforce it, and the judiciary will interpret it. Each of these organs serves both as a partner to the other two, as well as a restraint on each other, ensuring that the collective exercise of power by the parliament, the executive, the judiciary, keeping in sync with the common objective of doing good. So ensuring that the exercise of power remains balanced, accountable, and grounded only and only in justice. It is this balance, this equilibrium, that our own constitutional order seeks to preserve, recognizing that the true strength of the state lies not in the concentration of power, but in its just distribution. Judiciary, we talk about now. So the true strength of the state lies not in the concentration of power, but in its just distribution, reflected famously, for example, in Article 22 of our Constitution, which mandates the separation, an issue very close to my heart, separation of the judiciary from the executive.
Not yet happened. We hope, we wish.
We've created benchmarks. If someone asked me today, I was thinking that I will not discuss this issue today because it's so topical and it is also sub judice. But one can't deny my personal involvement for 17 months that I held office and the collective endeavors of the organ I represent, the judiciary, my 2,000 plus officers, judicial officers, our international stakeholders, and of course, the great people of this country. We created something. And we are very proud that we did. We achieved what was deemed to be unachievable. We attained what was deemed to be unattainable, and unprecedentedly so. Because there was this meeting of minds and meeting of social, political, personal will to forge ahead towards a common objective, true to the spirit of July and August 2024. So we were a very inspired nation. We're still a very inspired nation. We were an inspired nation. 4 months on, the ground realities are different, which I will not go into at all. So the question that may be asked is, what were your attainments past 17 months? And I will simply put it down to this. We created benchmarks. We showed the nation and the world what could be done, what can be done. If it has been done once, it can be done again, if need be. So we have created points of reference historically, legally, constitutionally. We've created reference points in the history of this great nation, which we hope will lead to something better and stronger. But never forgotten. So as I was saying, the law, by now, I think we see a consensus brewing in this hall, that the law does not merely signify a set of rules or principles governing particular areas of human conduct. It embodies a moral and a rational ideal. As Roscoe Pound so profoundly opined, law is a rational or ethical idea. A rule of right and justice deriving its authority from its intrinsic reasonableness and its conformity to ideals of right. This understanding reminds us that the law does not exist to command obedience. It is not the weaponization of the law. That is never the objective of the law itself and cannot be the intent of the lawmakers. Yes. You cannot turn law into a weapon for arbitrary, to extract arbitrarily command and obedience from the people. You cannot. Law must exist to command, at the end of the day, respect. Law draws its strength not from coercion. It is not inherently penal in nature, but from its moral credibility and its alignment with the conscience of society. And the judiciary, therefore, cannot be and must not be a passive interpreter of the law. Rather, the judiciary, and by the judiciary I mean I will include the bar and the bench, and possibly as a realist, an inspired idea that just sort of, gained foothold right now. The budding jurists who sit before me, you're all part of the judiciary. You have a stake in the future of the judiciary. All of us have to be active participants in shaping justice to ensure that our constitutional promises of the 1972 Constitution, or if we have a new constitution, that constitution must promise liberty, equality, and fairness to reach the doorstep of every citizen of this country. That is, again, I was talking about distributive justice. That is what I meant by distributive justice. Thus, it must be remembered that when fairness is served, state is strengthened, because the state is a sum total of all of us. If we are well looked after, if we are strong, the state is strong. If we are healthy, the state is healthy. But when justice fails, even the strongest state begins to crumble. And we have seen that in our history so many times. Ladies and gentlemen, the study of law, therefore, is no ordinary pursuit. It is the study of justice itself. It has faculties of reason, the deepest reserves of empathy, and a steadfast commitment to the rule of law. Note, therefore, that reflecting on the enduring impact of rule of law in the creation of just societies, and I would add, the evolution also of viable, sustainable states and relevant institutions, the incumbent Pope, Pope Leo XIV, addressing the Interparliamentary Conference on Combating Organized Crime in the OSCE region on just a few days ago, on 15th of May 2026, has aptly remarked that, and I quote, "The authentic implementation of the rule of law remains indispensable for a holistic, integrated human development." End quote. Premised on that declaration of Pope Leo XIV is the fact, I deduce from that behind every statute, every piece of legislation that you study as a student now, and that you will apply either as a judge or interpret as a judge or a lawyer, bear in mind that behind every piece of legislation lies a life of a citizen, of a human being. Behind every judgment lies the fate or destiny, again, of a human being. The true measure, therefore, of a legal professional lies not merely in the eloquence of their arguments, but in the quality of the justice their work delivers. Quietly, consistently, patiently, impartially, and enduringly. As our world grows more global, ethical, and technologically complex, legal education must also evolve accordingly. It must move far beyond merely doctrine. It must move on to cultivating instead critical reasoning, rigorous analysis, and a profound moral imagination. Looking at the road ahead, I am deeply confident that our institutions of legal learning will continue to nurture jurists who are not only learned in the law, but enlightened in spirit. The nation, and I personally, individually, look to you now, not merely to engage in the study of law as abstractions, not just to practice law as a trade, but to defend the nation's, a rejuvenate, revived nation's constitutional vision, to uphold rights, advance equality, and ensure that the doors of justice always remain open in truth and in deed to all. For true justice is never found solely in the pages of a statute book, but in the courage to apply the law humanely. Thank you ever so much.
Sir, thank you very much for your enlightening, insightful, and I must say, thought-provoking lecture, sir. Your valuable words will undoubtedly inspire students and enrich our academic journey. And from that point of view, we are too much